Something changed in California on January 1st that most drivers still haven't fully registered. Not with fanfare or major headlines, but through a suite of DMV regulatory updates that quietly rewrite the enforcement landscape across the state's roadways. We're talking about expanded automated camera systems now tracking red light and speed violations in cities like Malibu, $1,000 fines for license plate obstruction devices that were previously gray area accessories, probation terms for vehicular manslaughter, while intoxicated jumping from 2 years to as high as 5, and a 3-day cancellation window on vehicle purchases under $50,000 that fundamentally shifts leverage in dealer negotiations. These aren't minor technical adjustments. They represent a structural change in how California regulates driver behavior, enforces compliance, and balances consumer protection against industry interests. And they're already in effect, while most people are still operating under last year's assumptions. The economic implications extend beyond individual fines. Automated enforcement systems create new revenue streams for municipalities while simultaneously generating data trails that insurers and fleet operators will inevitably price into their models. The new ignition interlock extensions and harsher DUI probation standards signal a long-term tightening that affects not just individual drivers, but the broader mobility ecosystem, from rideshare eligibility to commercial driving employment. And the consumer protections in the CARS Act, while marketed as driver-friendly, introduce friction into an auto retail sector already navigating thin margins and inventory challenges. This isn't speculation about what might happen. These laws are active now, enforcement has begun, and the ground has quietly shifted beneath one of the largest driving populations in the country. Let's start with what actually happened, because the details matter here. California's legislature passed a series of vehicle code amendments and consumer protection statutes throughout 2024 and 2025, many of which were signed into law with staggered implementation dates. Some took effect on January 1st of this year, others are rolling out incrementally through the spring and summer, and a few won't be fully operational until later in the year when the necessary infrastructure is in place. The result is a patchwork of new rules that don't announce themselves clearly to the average driver, but carry real financial and legal consequences once you run into them. And the thing is, most people won't realize they've run into them until they're already dealing with a citation, a denied transaction, or a compliance issue that's going to cost them time and money to resolve. The automated enforcement expansion is probably the most visible change, even though it's happening quietly. California has had red light cameras in certain cities for years, but the scope was limited, and the legal framework was inconsistent enough that challenges were common. What changed is that the state legislature gave municipalities broader authority to deploy automated speed enforcement systems in designated safety corridors, school zones, and high-accident areas, with standardized fine structures and appeal processes that are harder to contest. Malibu is one of the early adopters, but other cities, including San Francisco, San Jose, and parts of Los Angeles County, are moving forward with similar systems. The cameras aren't just for red lights anymore. They're tracking speed violations in zones where the posted limit drops suddenly, where pedestrian traffic is high, or where historical data shows elevated collision rates. The fines start at $100 for minor speeding infractions and scale up depending on how far over the limit you were going and whether you were in a school zone or construction area. If you're 15 miles over in a designated corridor, you could be looking at $300 or more, and that's before any additional penalties if the violation occurred during restricted hours. Now, the justification for this is straightforward and, on the surface, reasonable. California has struggled with traffic fatalities for years, particularly pedestrian deaths in urban areas. Automated enforcement is sold as a way to reduce dangerous driving behavior without requiring constant physical patrols, which are expensive and logistically difficult to maintain. The data from other states and countries that use similar systems does show some reduction in speeding and red light violations in areas where cameras are installed. But there's a secondary effect that doesn't get discussed as openly, which is the revenue component. Automated systems generate consistent, predictable income for municipalities, and once that infrastructure is in place and the tickets start flowing, it becomes a line item in budget projections. That creates an incentive structure where cities begin to rely on traffic fine revenue, and the enforcement priorities start to blur between public safety and fiscal necessity. You see this pattern in other states where automated systems have been in place for a decade or more. Initial deployments are framed around safety, but over time, the number of cameras increases, the designated zones expand, and the fine schedules get adjusted upward. It's not corruption in the traditional sense, but it is a shift in how local governments think about traffic enforcement as a revenue tool rather than purely a public safety function. Then there's the license plate obstruction law, which is deceptively simple, but has real teeth. California previously had rules against obstructed or illegible plates, but enforcement was inconsistent and the penalties were relatively minor. What changed is that the new statute specifically targets devices designed to obscure plates from automated cameras or toll readers, including covers with polarized or reflective coatings, retractable frames, and spray coatings marketed as camera blocking solutions. Possession of these devices on a registered vehicle is now a misdemeanor, with fines starting at $1,000 for a first offense. The law doesn't just penalize obstruction, it penalizes the intent to obstruct, which means that even if you weren't actively trying to evade a toll or a camera at the time you were pulled over, having the device installed is itself a violation. This ties directly into the automated enforcement expansion because the state is closing the loophole that some drivers were using to avoid tickets. But it also raises questions about enforcement consistency and whether this becomes another tool for pretextual stops, particularly in communities where relations between law enforcement and residents are already strained. The CARS Act, which is the acronym for the California Automobile Retail Standards Act, introduces a 3-day right of rescission on vehicle purchases under $50,000. This means that if you buy a car from a licensed dealer in California and the purchase price is below that threshold, you have 72 hours from the time of sale to cancel the contract and return the vehicle. No questions asked, as long as the car hasn't been driven more than 250 miles and is returned in substantially the same condition. You get your down payment and trade-in back, minus a restocking fee that's capped at $500 or 1% of the purchase price, whichever is less. The intent here is consumer protection. Car buying in the United States, and particularly in California, where the market is massive and competitive, has long been criticized for high-pressure sales tactics, financing tricks, and buyers who feel rushed into decisions they regret within days. The 3-day window gives people a chance to cool off, review the terms, and back out if they realize they've made a mistake. But from the dealer's perspective, this introduces significant operational complexity. A car that's sold, driven for 2 days, and then returned has to be re-inspected, potentially reconditioned, and relisted, all while the dealership has already processed financing, registered the sale, and possibly paid out commissions. The economic impact on dealerships, especially smaller independent lots operating on thin margins, is not trivial. And there's a secondary concern that some buyers might abuse the provision, essentially using it as a free rental period, though the mileage cap and restocking fee are designed to discourage that. What makes this interesting from a policy standpoint is that it represents a shift in how California thinks about consumer protection in high-value transactions. Real estate has cooling-off periods. Credit card debt has dispute mechanisms. But vehicle purchases have traditionally been considered final once you drive off the lot, and the burden has been on the buyer to do their due diligence beforehand. This law flips that assumption and places more responsibility on the seller to ensure that the buyer is informed and confident before the deal becomes binding. It's a win for consumers in theory, but it also adds friction to a market that's already dealing with inventory shortages, supply chain disruptions from the past few years, and financing conditions that are tighter than they were a decade ago. Dealerships are going to price this risk into their operations somehow, whether that's through higher upfront costs, less flexibility on negotiations, or stricter qualification requirements for buyers who might be considered higher risk for cancellations. Now, let's talk about the DUI and vehicular manslaughter changes, because these are where the legal consequences get significantly heavier. California already had some of the strictest DUI laws in the country, with mandatory ignition interlock device requirements for all DUI convictions, even first-time offenses. What changed is the duration of those requirements and the probation terms for cases involving injury or death. Previously, a first-time DUI without injury might result in a 6-month interlock requirement and informal probation for 3 years. Under the new framework, the interlock period can extend to a full year, and the probation terms for DUI with injury or vehicular manslaughter while intoxicated have been increased from a range of 2 to 4 years to a range of 3 to 5 years, with judges having less discretion to reduce those terms in plea agreements. For vehicular manslaughter while intoxicated, which is a wobbler offense that can be charged as either a misdemeanor or a felony, depending on the circumstances, the probation extension means that even in cases where the defendant avoids prison time, they're looking at a 5-year period of court supervision, compliance monitoring, and restrictions that affect employment, housing, and basic mobility. The rationale here is deterrence and accountability. California, like most states, has seen persistent issues with repeat DUI offenders and cases where intoxicated driving results in serious injury or death. The public safety argument is that longer probation periods and stricter device requirements reduce recidivism and give the courts more time to monitor compliance and intervene if someone starts to slide back into problematic behavior. But there's also a practical reality that longer probation terms and extended interlock requirements create a financial burden on defendants, many of whom are already struggling with legal fees, fines, restitution, and the collateral costs of losing a license or employment. Ignition interlock devices aren't free. They cost between $70 and $150 a month to lease and maintain, and that's an ongoing expense that adds up quickly over a year or more. For someone who's already dealing with court costs and potentially reduced income because they can't drive for work, that's a significant financial strain. And if they fall behind on payments or violate the terms of their probation, they're looking at additional penalties, possible jail time, and an extension of the probation period, which creates a cycle that's hard to break. There's also a broader policy question about how much of California's criminal justice system is being funded by fines and fees, and whether that creates equity issues for low-income defendants. This isn't unique to DUI laws. It's a pattern you see across the state's legal system, where the cost of compliance with court orders, probation terms, and mandatory programs is effectively subsidized by the people who can least afford it. And when those costs become insurmountable, people end up back in the system for technical violations rather than new criminal conduct, which defeats the purpose of rehabilitation and contributes to the overcrowding and backlog issues that California's courts have been dealing with for years. From an economic standpoint, these law changes also affect industries that most people don't think about. Rideshare companies like Uber and Lyft have strict background check and driving record requirements, and a DUI conviction with an extended probation period and interlock requirement is usually disqualifying, either permanently or for the duration of the probation. That means drivers who might have been able to continue working in the gig economy under the old framework are now locked out for longer periods, which affects their income and increases reliance on other forms of support. Commercial driving licenses face even stricter scrutiny. A DUI conviction can result in a CDL being suspended or revoked, and even after reinstatement, many employers won't hire drivers with recent DUI history because of insurance liability. So the ripple effects of these harsher penalties extend into labor markets, household income stability, and the broader question of how California supports economic mobility for people with criminal records. The rollout of these changes hasn't been accompanied by a major public awareness campaign. There were some notices on the DMV website, a few press releases from the governor's office, and coverage in local news outlets, but nothing that reached the level of widespread public consciousness. That's partly because legislative changes to vehicle codes don't generate the same attention as ballot initiatives or high-profile policy debates, and partly because the implementation is fragmented across different agencies and municipalities. The automated enforcement systems are being deployed city by city. The CARS Act is being implemented by dealerships as they update their sales contracts and compliance procedures. The DUI and probation changes are being applied case by case as new convictions come through the courts. So there's no single moment where everyone in California wakes up and realizes the rules have changed. It's a gradual process where people find out when they personally encounter one of these new provisions, and by that point, they're already dealing with the consequences. What's particularly striking is how these changes reflect California's broader approach to regulation and governance. The state has always positioned itself as a leader on progressive policy, whether that's environmental standards, labor protections, or consumer rights. And in many ways, these DMV law changes fit that pattern. Automated enforcement is framed as a public safety innovation. The CARS Act is presented as a win for consumer protection. The DUI probation extensions are sold as accountability measures, but there's also a tension between the stated goals of these policies and the practical realities of how they're implemented and who bears the cost. Automated cameras generate revenue that cities come to depend on. Consumer protection rules add friction to markets that are already under pressure. Harsher DUI penalties create financial burdens that disproportionately affect low-income defendants. And all of this is happening in a state that's already dealing with housing affordability crises, infrastructure challenges, and budget constraints that limit how much support can be provided to the people most affected by these changes. The national implications are worth considering too, because California often serves as a testing ground for policies that eventually spread to other states. The CARS Act, if it proves successful in reducing buyer's remorse and dealer misconduct without collapsing the auto retail market, could become a model for similar legislation elsewhere. The automated enforcement expansion, if it demonstrates measurable reductions in traffic fatalities without creating significant backlash over privacy or revenue concerns, could accelerate adoption in states that have been hesitant to move forward with camera-based systems. And the DUI probation changes, if they show reductions in recidivism, could influence sentencing guidelines in other jurisdictions. California's size and economic weight mean that what happens here doesn't stay here. It influences manufacturers, insurers, tech companies, and policymakers across the country who are watching to see what works, what doesn't, and what the unintended consequences turn out to be. So, where does that leave the average California driver right now in February of 2026? It leaves them navigating a regulatory environment that's quietly become more complex, more expensive to violate, and more interconnected with technology and data systems than it was a year ago. The smart move is to treat this as a reset moment. If you drive in California, assume that speed limits in designated zones are being monitored automatically, that your license plate needs to be fully visible and unobstructed, that any vehicle purchase under $50,000 comes with a 3-day window to reconsider, and that DUI or reckless driving violations are going to carry longer-term consequences than they did under the previous framework. None of this requires panic or drastic changes to how you live your life, but it does require awareness and adjustment. The rules have changed, enforcement has changed, and the financial stakes have changed, and the people who adapt quickly are going to have an easier time than the people who find out the hard way.